speaker of the day is Advocate Pallavi Pratap. Advocate Pallavi Pratap is an advocate on record in Honorable Supreme Court of India. She practices in both criminal and civil side. A former investment banker, she brings with her over a decade of experience in litigation. She has an honors degree in history from Jesus and Mary College, University of Delhi, MBA in finance from Caltech University, Melbourne, Australia, and a degree in law from Lucknow University. Over to you now.
Thank you so much, Ananya. I hope I'm audible to everybody.
Yeah,
Yeah.
yeah, go ahead.
So I will actually just start my presentation just now. Primarily, in my presentation, we've been yeah, there you go. So my presentation primarily is on the judicial impact of forensic science in criminal investigation. How much of judgments have been affected by the forensic science evidence, how the courts actually tackle it, and which are the very fundamental cases which brought about this entire watershed moment as far as criminal investigation was concerned, and especially criminal law was concerned. Um, I would basically, as Anuj very rightly pointed out, what forensic science is all about. I would just want you guys to have a look at a little bit of something that we wanted to add. So, science in this sense, a lot of people tell us, and we've seen through a lot of movies and serials which keep coming in, that a dead body kind of speaks to everybody. The crime scene tells you about who the perpetrator is. It points out completely to the criminal. So therefore, if we look at it, forensic science is basically a scientific study for investigation of crime, and it kind of has all the components of science included into it. So you would see that physics is used to understand the pattern of a blood spatter, or biology is used to establish the source of an unidentified suspect. And similarly, chemistry is used to determine the composition of drugs. I think the other panelists who are there, who are going to be speaking on lately, would be in a better position to delve on the scientific part of it. I, being a lawyer, I absolutely do not have too much understanding of it, but I'm going to look at how it is applied. What is the procedure? What does the Indian Evidence Act speak about it? What are the CRPC provisions, and what are the leading judgments where we found about the applicability of forensic science? So the key components, some of these slides may be a little gory, so people with a weak heart may just not look at it if they want to. The key components of forensic investigation, there is a crime scene. How is a crime scene preserved? I think that is also an important component, because we see that in even in places like urban India, a lot of times the crime scene gets tempered because of so many ways in which maybe the investigators are not able to identify certain areas which should have been kept remote, or a lot of times when recovery is done of the assault weapon, the recovery memo which is made a lot of times has it requires to have at least witnesses who are independent, but many a times a case gets actually it completely falls apart only because in the recovery memo maybe the people who have signed it are not independent witnesses. The recording of the crime scene, like I just told you about, is covered under how the recovery etc. is made. Now, scene of occurrence or crime scene. A scene of occurrence can be defined as a meeting place of the persons involved in the crime, and traces are exchanged by the parties amongst themselves and with the scene, leaving odds and ends and mark of tools, wearing apparels and means of transports, hands and feet. So it could be just leaving behind the hair strand or something of that sort, or the tire marks. Or maybe leaving behind fingerprints. These are important things that actually lead for a forensic expert to understand who could have been a perpetrator of an offense. Similarly, the scene of occurrence provides a wealth of information which which is useful, I guess, to establish corpus delicti, provide link between the criminal, the victim, and the scene of occurrence, and evaluate the pattern of events. I think all of this really speaks volumes, and I think the forensic scientists and our FSL officers actually bring about a lot of difference in terms of arriving at and also corroborating the evidences which are there for a judge to arrive at, to understand the quantum of punishment and to arrive at whether or not the crime was perpetuated by the accused who's there. Similarly, forensic science and the law of evidence, I think, is a very interesting part that we need to understand. How is law of evidence treating them? Now, we've seen in catena of judgments from the Honorable Supreme Court that the expert opinion is given prominence. However, there are judgments on the other side of it as well. But if we look at Section 45 of the Indian Evidence Act, we would see that opinions of experts, I've just taken out, to form an opinion upon a point of foreign law or of science or art, or as to identify, or as to identity of handwriting opinions upon that point of persons specially skilled in such foreign law, science, or art are relevant facts, and this also includes your fingerprints, etc. So any forensic lab report that comes, a lot of times we've seen in 376 cases that there is a forensic lab report that comes of maybe the presence of sperm, for example, which then is cross-checked with those of the accused, and that kind of helps in corroborating a certain thing. Or it could also be the victim's blood samples, which then are when there is a difficulty in identity of a victim, that the blood samples actually help in terms of ascertaining who the victim really was. This we will see in the case laws that follow. So, judicial development of forensic science in India, if we look at it, I think to my mind, the first case which kind of brought everything into prominence, a lot of media attention was given, was the famous Tandoor case, where a lady by the name of Naina Sahani was found murdered, and her body was being burnt alive in a tandoor in central Delhi. And it was an entire investigation, and if we look at it, the judgment very, very clearly talks about the judgment of Honorable Supreme Court, as also that of the trial court and the High Court. We see how they have picked up pieces of each and every evidence and corroborated it. It's a wonderfully drafted judgment, and talks about not just about the investigation part of it, but also on the sentence, quantum of sentence, and if how 366 can be used. So it's an exhaustive judgment, but primarily, if you look at it, this was the case where we would see that in order to identify the victim, the blood samples of the victim was taken, and then it was cross-checked with those of the parents in order to see the DNA profiling. A very interesting judgment, and how they actually arrived at. There were DNA profiling, there was hair, there was dried blood which was found in the dicky, and the argument of the accused's counsel was that dried blood was basically not of human being, but then how the investigation, the forensic actually ascertains that no, it was a human blood. And to put the 2 and 2 together and build up a case, I think that was an amazing thing that was done when technology was also not so advanced way back in 1995. How the evidence was actually kept. There were post-mortem which was done twice. How they arrived at ballistic reports. I think it's an interesting judgment for all of you to read. Maybe Anuj can later share the link of the judgment, and you can all go through it. Similarly, if you would all remember, this is a 2011 very recent case where Inspector of Police versus John David. Now, this was a case which brought about fundamental change in a lot of things, not just in forensics, but also this was the case which actually brought about anti-ragging laws. So this poor boy who was studying in the first year of medical college was assassinated by this gentleman called John David, and he chopped his body and threw the pieces all across Tamil Nadu. And then how they ascertained all these pieces of a dead body and then came to a conclusion that this belongs to the victim. I think the DNA profiling, human identification, everything which was done speaks volumes about the kind of forensic investigation which was done, the criminal investigation which was done, and how forensic science was used to arrive at providing justice, not just to the deceased, but also to the deceased's family. The father of the deceased has been running very successfully an NGO which is on anti-ragging sentiments. Then, of course, we had the Nitish Guitarra case, which I believe was again another case where we see that forensic science again played a very important role, especially for the detection of the deceased victim was difficult due to the availability of only a small portion of one unburnt palm with fingers. And here also DNA profile helped in identifying the body remains by matching DNA profile with those of the parents of the deceased, which helped the High Court of Delhi to uphold the conviction of the accused. So we've seen that in many cases, the court is assisted by this evidence which comes in. It is assisted by these forensic scientists, the FSL laboratories, who really provide a lot of support and the kind of reports that come, even though they are delayed, and no doubt about it that FSLs are actually overburdened by so many things, so many cases that are sent to them, but nonetheless they are doing a fantastic job as far as that goes. Then so we've also seen in criminal cases that there is always a prominence when it comes to medical evidence as well as ocular evidence. There's a prominence which is always given to the ocular evidence, where they feel that if the ocular evidence is there and it is supported by a trustworthy and a reliable witness, then that will have precedence over medical evidence. However, this has in many cases this has been changed also. It has been set aside, where medical evidence based on the reports, based on the circumstantial evidences, has brought about that prominence, that medical evidence can also be given prominence over that of ocular evidence. Then going forward, one of the questions I think that really comes to our mind is that is polygraph or brain mapping or lie detection, so to say, really something which advances the truth? Is it really true that you're able to see the truth and honesty actually speaks vociferously? There are two sides to the same argument. In some judgments, a polygraph test has been given precedence. However, later on, as the criminal jurisprudence kind of evolved, we see that a polygraph test was not given so much prominence, because a lot of times it was seen that accused could actually control his responses to a specific question. And also, I think that especially in Selvi versus State of Karnataka, it was said that this is primarily going against the fundamental right, the right to privacy of an individual. So, like it says, the Supreme Court of India, with regard to these tests, has held in Selvi that it expressly invoked the right of privacy to hold these technologies unconstitutional, stating that such techniques invaded the accused's mental privacy, which was an integral aspect of personal liberty. However, this definitely was covered under the right to privacy, but there have been instances where it is seen that a lie detecting test is actually not really bringing about the character of an accused. So that's regarding the lie detection test. Mukhtar Singh versus State of Punjab was a very interesting case. Now, I think a lot of times what we see is that evidence which is there is primarily, as far as ballistics are concerned, is related to, let's say, the caliber of the revolver vis-a-vis the cartridges which were used. Now, even in the Tandoor case, we see that the accused actually had a .32 caliber revolver, and the ballistics which were used, or sorry, the bullets which were used. There were some 10 of these which were found in the house. The fires, 2 in the skull, 1 in the ply of the house, 1 inside the carpet. So maybe the number of bullets which were fired could have been essentially a question of a question which was open-ended. However, what was ascertained was that the bullet which was found pierced in the skull of the victim was actually fired from the same revolver which was recovered from the accused. So I think this is exactly what happened in Mukhtar Singh's case also, where Supreme Court accepted the forensic science experts' evidence, which was produced by the prosecution, of course, that the fired cartridges and the missed cartridges found were fired from the same rifle which was recovered. Similarly, Dharmdev Yadav, I think this is one of the recent cases that we've seen, and here we see that modern forensic techniques were used, and this was not just DNA profiling, because we've seen it in criminal investigation, especially when we are doing trials. We see that a lot of times the witnesses who are there, they turn hostile, and then you've built up a strong case. You've got your 161, you've got your 164, you've got all these evidences. You go in the trial, and then you realize that suddenly your star witness turns hostile and says, I have no idea, I did not give that statement, I gave the statement only under pressure. And that kind of crumbles the entire case of the prosecution. But like we discussed before, this crime scene, the victim's body, speaks volumes. And I think with the kind of acceptability that forensic science is getting right now in India, and with the kind of technology which has started to come for our rescue, it is interesting to see how this has actually started to evolve. And Dharmdev Yadav happens to be that case where we see that modern forensic techniques for criminal investigations, such as DNA profiling, have been lauded because of reliable witnesses failing to give testimony or turning hostile due to intimidation. Though it is conceded that DNA testing may be in particular case not be cent% accurate, as that would depend on the quality of the analysis and whether the sample collected was kept free from contamination. This, I think, is a very big challenge for India, because obviously with the kind of terrains that we live in, the kind of weather conditions which are there in the country, and also the lack of police being trained in terms of how to collect evidences or to keep them safely. I think all of that actually is a huge issue or a huge challenge that we foresee. However, having said all of that, I think the police is doing really wonderful job as far as collecting samples is concerned and processing them is concerned. So I think we should give it to the different police officers there. Then, of course, state of NCT Delhi versus Sujit Kumar. Now, it is not that we see that forensic science is only being used as far as murder is concerned. 302 is the only one. I think 376 hugely benefits from the forensic science, especially as far as rape is concerned. It is huge, because this is how you are able to ascertain who the real culprit was. Just as we see state of NCT Delhi versus Sujit Kumar, brutal rape and unnatural sexual act with a 4-year-old child living in a slum dwelling was investigated by Delhi police, and DNA profiling was used to link the perpetrator with the ghastly act of sexual violence. The court, after having examined the detailed analysis analysis of a child's testimony and various methodologies involved, approved the investigation findings based on the DNA reports and other evidences, and held the accused guilty and set aside acquittal order passed by the lower court. We have to understand that uh, the judges basically have to be assisted by the evidences, and it is our duty as lawyers to ensure that when we are from a prosecution side, especially when we are for the prosecution side, all these reports should be brought forth and should be made available to the judges for them to understand and to analyze, because they are in the best position to analyze all of this. And DNA profiling, etc. Even though I remember when I was a state counsel, every time we would see that any you know report would take at least a couple of months for it to come, and that would give a lot of time to the accused to actually tamper with evidences here and there, specifically with the witnesses, which I think was what created a lot of trouble for people to gather as much evidence as possible against accused, especially in 376 matters, because we've seen there are a lot of times they actually approach the girl who has been raped, and by offering them some money, they would want the girl to actually withdraw the case. But one has to understand that these cases are always seen as crime against the state and not just one person in particular. So therefore, the punishment or the quantum of punishment is actually decided by that, by the criminal antecedents and what kind of a history does a criminal have. So coming to the importance of forensics for lawyers, Justice Malimat in his report had said that the bar has to realize the importance of specialization and learn, for example, the nature and scope of forensic in detection and proof. Lawyers and judges should be receptive to change on the benefits of technology, should be fully utilized. So the idea is that not just the bench, but the bar also needs to be needs to learn about what is the latest as far as forensics is concerned. I think Modi's jurisprudence is one Bible that really helps all the criminal lawyers, especially for coming in terms of ascertaining. Let's say if there is an injury, what kind of an injury it is, if it's a bullet injury, if does it have a dark, discoloration nearby, which would then mean that the fire shot was actually done from a close distance, or does it have it? Does it not have that discoloration? So that basically means that it was from a far distance. Those kind of inputs which are there in Modi's jurisprudence. I think for any criminal lawyer, I think it is the Bible for all of us. And it is important, like Legal Desires conference like this today, where we will learn so many things, which is more of a capacity building for us lawyers to understand, who are practicing in criminal side, to understand what is happening in the world and what are these different things that that can help us to corroborate our evidence further. So now. There are some challenges now that I would like to talk about. Restrictive use of forensic science in Indian legal scenario. The most important function of forensic investigation is to exchange doubt into reasonable certainty of either guilt or innocence. However, till recently, the courts had to depend heavily on the non-scientific evidence because of the non-availability of proper technology. But we've seen that it has changed in the past 20 years or so. There is a huge dependence now on forensic reports, and there is a huge dependence now. It is not just the witnesses who are turning hostile, which may crash your case. We will also see that these reports then actually come to the rescue of the prosecution to establish their case properly. Similarly, this is just a slide which kind of tells you about how much have we seen, especially in Supreme Court and High Court. The study was conducted in 2011, so some 10 years back, and this shows about 47 cases were relying upon the forensic, and where DNA had played a very important role. Out of these, 23.4% decisions were given by Delhi High Court alone. And furthermore, DNA evidence had been used in nearly 4.7% murder cases and 2.3% rape and murder. So we are seeing that this happens to be about a decade old survey. But if we look at that study now in, let's say, 2020 or 2021, we will see there must be a remarkable change and at least 5 times increase as far as on a very a lower side of it. I feel that 5 to 10 times increase in the cases must be there as far as reported cases are concerned. Because even if you look at it, for the juvenile, for ascertaining whether a person is juvenile or not, the ossification test that is conducted, I think that also then becomes part of forensics only. If you are trying to figure out, even though it is a medical report that is there, however, these reports are being asked increasingly by the judges to ascertain whether or not a person was, a juvenile at the time of commission of the offense. So I think science and forensic science has specifically been very helpful to us for expeditiously, for expeditious justice to be delivered. In conclusion, I feel that sometimes scientific evidence suffers from some kind of technical lacunas. For example, if there is a report which is there and it does not mention the blood group of the victim, the defense can actually just tear that report apart and say that this does not really apply for us. However, this kind of meticulousness has to be shown by the FSL officers who are conducting these investigations. There are so many times that we see that no supportive data is provided, or there is delay in examination of exhibits at the laboratory. I think Sunanda Pushkar case is again one of these examples where we see that even though Viscera was kept in for a long time to understand the toxicological report, these are all cases that will actually provide us, especially I think Sunanda Pushkar case will definitely provide us an intense understanding in the forensic science and the applicability of it. So I think that's about it from me. Over to you, Anuj, if you're there.